the Child Care and Protection Act, Section 30, Contribution Orders. Subsection 1. A contribution order may be made in accordance with this section where a fit person order or a correctional order has been made in respect of a child. Subsection 2. The contribution order may be made it may be made by a court which makes the fit person order or the correctional order at the same time when it makes that order, or it may make that order subject to the provisions of Section 32 by any court or summary jurisdiction having jurisdiction in the place where the person is to be charged, where the person to be charged is for the time being residing on the application of 1. The person to whose care the child is committed. 2. The minister in the case of the committal to a juvenile correctional center. So the contribution order will be the order for you to make contribution to the maintenance of a child. It may be made by the person who is caring for the child, or it may be made by the Minister of Justice if the child is in a juvenile correctional center. Alright? Subsection 3. The contribution order shall require any person who is liable to make contributions under Section 29 in respect of any child to contribute such sum as the court thinks fit having regards to his means. So the court thinks fit that you can afford this amount, then the court will make that order. Alright. So, subsection 4. A contribution order A shall, unless varied or revoked, remain in force so long as the child remains in the care of the fit person or juvenile correctional center, and the court which, when making such order, shall have regard to any affiliation order in force in respect of the child. B. The contribution order may be varied or revoked on the application of either the contributor or the government agency responsible for children. Subsection 5. A contribution order shall be enforceable A. Where a child has been committed to the care of a fit person at the instance of the government agency, at the instance of the government agency responsible for children, or it shall be enforceable where a child has been committed to a juvenile correctional center at the instance of the minister in the same manner as an affiliation order made under the Affiliation Act. Subsection 6. A person against whom a contribution order is made shall, if he changes his address, forthwith give notice thereof to the government agency responsible for children, and any person who fails to comply with the provisions of this subsection, or who knowingly gives notice that is false in any material particular commits an offense against this act. Okay, so if you have a child and the child is taken from you to another person or a juvenile correctional center, and there is a contribution order against you. So you are the mother or the father, and you, the court say you must contribute to the child, and you contribute to the child, and then you change your address. You move from one apartment to another, then immediately you have to inform the court, right? What it say? Forthwith give notice to the government agency, right? The government agency responsible for children. You have to give notice to them immediately. Or if you don't do that, or if you give a false address, then you commit an offense against this act. Section 31, provisions as to affiliation order. Subsection 1. Subsection 2 or 3 shall apply where a court makes a fit person order or a correctional order and an order for the child's maintenance is in force. Subsection 2. This court, the court which makes the order referred to in subsection 1 may at the same time order the payments under the maintenance order to be paid to the person to whom contributions in respect of the child are payable under section 29. So the court which make the order referred to in subsection 1 may at the same time order the payments on. Okay, so they can order you to make those payments under the maintenance order to be paid to the person whom contribution is in respect of the child. Alright? Whoever take care of the child, they can order you to make the money go to that person's account, that person's bank account. 3. Subject to the provisions of section 32, the powers of the court under subsection 2 may be exercised by any court of summary jurisdiction having jurisdiction in the place where the putative father is for the time being residing. Read that again. Subject to the provision of section 32, the powers of the court under subsection 2 may be exercised by any court of summary jurisdiction having jurisdiction in the place where the putative father is for the time being residing, on the application of the person who would be entitled to apply for a contribution order. Alright? So the courts that have jurisdiction on the application of a person who would be entitled to apply. Also, if you the father live at one address in one jurisdiction and the person who make the order live in another jurisdiction, right? Then it say the order may be exercised by any court of summary jurisdiction having jurisdiction in the place where the putative father is for the time being residing. Alright. Subsection 4. Any sums received under the maintenance order shall be applied in like manner as if they were contributions received under a contribution order. Subsection 5. If the putative father changes his address, he shall forthwith give notice thereof to the government agency responsible for children, and if he fails to do so, or if he knowingly gives a notice that is false in any material particular, he, commits an offense against this act. Subsection 6. The making of an order under this section with respect to a maintenance order shall not extend to the duration of that order. Alright, subsection 32. Reference in section 30 or 31 to court for Kingston and St. Andrew is to family court. Subsection 1. Any reference in section 30 subsection 2b or section 31 subsection 3 to a court having jurisdiction in any place of residence for the time being shall A. in relation to a place in the parish of Kingston or the parish of St. Andrew be construed as a reference to the family court, corporate area region, and B. in relation to a place aforesaid in a parish within the geographical jurisdiction of a family court established pursuant to Part 2 of the Judiciary Family Court Act shall be construed as a reference to that family court.